Welcome to the training video for the right to counsel. My name is Ryan Flynn. I'm an assistant county attorney in Chisago County. Today's video is going to talk about the right to counsel that a defendant has during the implied consent advisory process. In 1991, the Minnesota Supreme Court decided in Freeman that a defendant has the right, a limited right, to speak with counsel before deciding whether or not they should take a chemical test. Now, you as law enforcement have some certain obligations that you have to follow. In reviewing the case law, we've broken down those obligations for you to three primary areas. First, you have to give a defendant the opportunity, then you have to give them the ability, and then thirdly, you have to give them the time. By opportunity, we primarily mean you have to ask the question. As you're reading the implied consent advisory, you'll go through, as the advisory says, whether or not they understand it, and then that second question is whether or not they wish to consult with an attorney prior to deciding whether or not to take that test. Simply read the question to them, and the burden shifts to the defendant to make it clear to you that they affirmatively want to speak to an attorney. That's as simple as it sounds. If they say yes, sure, I think so, yep, anything along those lines, then the courts will decide that they affirmatively asked for that to use that opportunity to speak with an attorney. Now, it goes the other way as well. Frankly, no means no. If they say no, nah, not right now, or I don't know, if they stare at you in silence or say something along the lines of I don't think so, all those things are interpreted by courts as waiving that right to speak to counsel. If there is any sort of lack of clarity or ambiguity in their response, then you as law enforcement should seek to clarify what they want to do. So if they kind of or ha or say, you know, I'm not sure right now, or something along those lines, simply ask them a clarifying question, which is just as simple as saying, just to be clear, do you or do you not want to speak with an attorney? If they still give you kind of an ambiguous answer, go ahead and tell them, I need a yes or no. Try to get them to say that they do or they don't. If you're in a situation in which you just can't figure out whether or not they want to speak to an attorney or don't, go ahead and give them a telephone and a phone book anyways. Wait 10 minutes and see what they do. Now, obviously a lot of times people will say that they wish to speak to an attorney, but then they'll proceed to frustrate the process. What I mean by that is they'll get the telephone and the phone book, but rather than looking through it, they'll push it on the floor. Or they'll start arguing with you or with a bailiff or with a jailer or somebody who's in the room. If they're doing that to the point where it appears that they're no longer being sincere about wanting to speak to an attorney, then go ahead and proceed with the implied consent process as they're waiving their right to an attorney. If a person begins frustrating that process or refuses to take any action at all, again, they're waiving their right to consult with that attorney, and you can proceed to the next phase of the implied consent advisory. There are the times when a person says that they don't wish to speak to an attorney, but just prior to giving that test result, change their mind and decide that they do wish to consult with counsel. In those situations, you should give them the opportunity. Now, the courts have said that if a person is beginning that testing phase or has been transported to a place where now it would be more difficult to step back and give them that opportunity, then you can let them know, unfortunately, we're past that phase of the process and you need to make a decision now. If somebody in mid-breath tests, for example, suddenly says, no, I've changed my mind, I want to speak to an attorney, too late. At that point, they're now frustrating the testing process, and you can either tell them to proceed with the test or tell them that they have to make a decision. The second area where you have an obligation regarding their right to counsel is to ensure that they have the ability to contact counsel. So once a person decides that they do wish to speak to an attorney, you have to provide them with a telephone and a phone book. Now, to be clear, it has to be a phone book that would allow them to choose their own attorney. You can't provide them with a pre-edited list of attorneys or, in one case, a blue page book which had an edited version of attorneys. The Court of Appeals have said that's simply not enough to give them the ability to consult with a counsel of their own choosing. For example, you can't contact the public defender's office and hand that phone to a defendant. Courts of Appeals have said that that is an improper influencing by law enforcement on a person So instead of allowing them to choose their own attorney, it would be law enforcement providing them with a specific attorney, and that is something that you shouldn't do. However, to clarify, a person doesn't have the right to a specific attorney. While they have a right to an attorney of their own choosing, that simply means they have the ability to contact attorneys that they want, and that decision is free from influence of law enforcement. It does not mean that you have to guarantee that they can reach the attorney that they want. If a person contacts attorney but can't get a hold of that attorney, then it is incumbent upon the defendant to try contacting another attorney. It is not incumbent on law enforcement to ensure that they get to speak to that one person. What you may consider doing, and what would probably improve your case, is if a person attempts to call an attorney, does not reach that attorney, and then sits there silently, you can suggest or ask them, do you want to contact a different attorney since you weren't able to get a hold of that your first attorney? Doing so will strengthen our argument that you validated their right to counsel. Because as you can imagine, many defendants attempt one attorney and then come into court later saying, I didn't have a right to counsel because I tried calling the one guy and he wasn't in his office. If you as law enforcement are able to say, I asked him if he wanted to speak to another attorney and he said no, it makes it much easier for the courts to find that law enforcement has vindicated a person's right to counsel. In some cases, a defendant will contact an attorney and the attorney will indicate that they wish to speak to the person in person, meaning the attorney will then travel to the jail or facility that the person's at in order to speak them face to face. You as law enforcement do not have an obligation to ensure that they have that opportunity. Rather, what you should do is wait an appropriate period of time, the same amount of time that you would normally wait, for example, if an attorney was going to call somebody back. If that person does arrive before you begin the testing process, go ahead and let them speak face to face. However, you do not need to pause a breath test, blood test, or urine test in order to allow the defendant to then go back to speak to their private attorney. Instead, if a private attorney does arrive and you have not started the testing process, go ahead and give them a moment, but they are not entitled to a private room. What that means is that Court of Appeals have examined whether or not there are safety concerns or whether or not there are concerns about unduly delaying the test. If you think that there's any sort of safety concerns, then you can keep them in an open room, but try to stand at a far side of the room so it doesn't appear that you're attempting to overhear or listen inappropriately to what the attorney and what the defendant are saying to each other. Sometimes there are situations in which a defendant, due to their driving conduct or due to other circumstances, they're injured or physically unable to dial a phone. In that situation, you should help them. Dial either a phone number and dial the number that they ask you to dial. So ask them to look at the attorneys, ask them to decide which attorneys' phone numbers you should be dialing, but do help them with the phone. Courts look very favorably on this, as obviously if somebody for some reason doesn't have the use of their hands or their arms, we cannot argue that we're vindicating their right to counsel by handing them a telephone that they simply cannot use. Go ahead, help them call the numbers, help them dial the phone numbers, and let them speak to the attorney if you're able to get a hold of one. If a person cannot speak either to a medical reason or due to a physical disability, then go ahead and try and use writing to communicate with the defendant. Now, it's a rare circumstance, but one that courts always, when it does happen, look with great scrutiny. They want to be sure that anybody, no matter their physical disability or medical condition, has the ability to speak with counsel. So if you are faced with that unique scenario, do your best to try and communicate with that defendant in writing to ensure that they had the opportunity and ability to speak with counsel. However, if a person is physically unable to speak to an attorney or physically unable to look for an attorney due to a medical process going on, the courts have said that you do not have to wait for that medical process to be over in order to ensure that they have the right to speak to an attorney. You can inform them that at this time, due to medical reasons, they're not able to speak to an attorney and they have to make the decision on their own. Another common question is whether or not long-distance telephone calls must be allowed. Generally speaking, the answer is going to be yes. If somebody in a more rural area of the state wishes to contact an attorney from Duluth or Rochester or the metro area, The Court of Appeals has said that that is okay and that they should be allowed to contact that attorney. Now, if they are attempting to contact long distance, but for some reason they're unable to, for example, the hospital doesn't allow long distance, or if the facility that you're in simply doesn't allow 1-800 numbers to be dialed, suggest to the defendant that they attempt to contact a different attorney or continue to attempt to contact the same attorney using a different number. In one particular case, the Court of Appeals said that because the defendant was not able to dial a 1-800 number, but because they then refused to try and reach the same attorney at a local number, the right to counsel was vindicated and the conviction would stand. Another increasingly common question is regarding the use of personal cell phones. Try to obtain a person's personal cell phone and go ahead and allow them to use it if they have a specific attorney's number. A lot of times there will be a question about whether or not a person should be allowed to contact a family member or a non-attorney. In such a case, you should allow them to contact the non-attorney or family member, even though that they are not an attorney. And the Court of Appeals has said that a person doesn't have a right to contact a family or non-attorney. However, what commonly happens in court is they tell you, I want to call my mom, or I want to call my brother, or I want to call my neighbor. Officers tell them you don't have a right to do that, and this is your time to contact an attorney. However, that person later comes into court and explains to the judge, I was trying to contact an attorney and my mom is the one who knew the attorney's name. So I couldn't contact our family attorney because I wasn't allowed to contact my mother. We then have a contested hearing about whether or not the defendant appropriately made the officer aware of the fact that their mother could have a number for an attorney. Rather than have to face that contested hearing, it is better practice to just allow that person to call whoever they want during a certain time. If a person wants to waste their time contacting their mother as opposed to contacting an attorney, frankly, that's their prerogative and not your problem. But allowing them to have that time forecloses a later argument that you denied their right to attorney. Something that's frequently asked by law enforcement is under what circumstances they're able to end a phone call between a defendant and their attorney. When a defendant reaches an attorney, it normally takes only between 10 and 15 minutes for them to have an appropriate conversation. However, sometimes that conversation goes longer, or due to the time that they reach the attorney, it begins to delay the test. When you feel that a test is about to be unreasonably delayed and that ending the call may be necessary, you should give at least a 2-minute warning, simply by pointing out to the defendant, hey, so-and-so, just letting you know that in 2 minutes I have to end the call and you'll have to make a decision. At the end of the 2 minutes, go ahead and let them know 2 minutes are up. You do have to make a decision at this point. If they refuse to hang up the phone, go ahead and hang up the phone for them and inform them that they need to make a decision regarding whether or not to test. The third thing that law enforcement needs to do is ensure that a person has an appropriate length of time. Now, calling it length of time is actually slightly misleading. The courts don't look at time. There's no time limit and there's no basic time requirement, meaning there's no floor and there is no ceiling. Instead, courts look to the good faith of the defendant in sincerely attempting to contact an attorney. That means if you've been giving somebody 3 minutes to contact an attorney, but during those 3 minutes they're arguing with you, or they're not looking at the phone book, or they have no interest in the phone, then you may be justified in going ahead and ending that period and telling them that they need to make a decision. The flip side is that sometimes up to an hour needs to be given to a person to be able to have a full conversation with their attorney. What courts look at when determining good faith is a totality of the circumstances. They look at everything from the time of day, the number of phone calls they attempted to make, when they were arrested, the time it took them to transport them to the jail, how long the implied consent advisory process took before giving them this opportunity to contact counsel. They look at the likelihood of the alcohol dissipating from their system, how sincerely they've attempted to contact multiple attorneys. So for example, if a person tries one phone number, doesn't reach somebody, doesn't leave a voicemail, and doesn't leave a number for them to call back to, but then hangs up the phone and doesn't do anything, the courts are not going to see that as a sincere attempt to continue contacting an attorney. When you feel that somebody is not being sincere, go ahead and turn on the recorder and just ask them, are you done speaking with an attorney? If they indicate that they want to continue speaking with an attorney, give them more time. But if they continue to do nothing, again, turn on the recorder and indicate, at this point it's been 5, 10, 20 minutes, Mr. or Mrs. So-and-so, and I've noticed you haven't attempted to contact an attorney, so at this time we are going to proceed. Finally, one of the most important things that you should keep in mind as law enforcement is documentation. While a DWI may take between 1 hour, possibly 3 to 4 hours, the fact is in the court process, a DWI can last anywhere between a year up to even 3 years. You may not be able to remember every single detail, but the defense attorney will certainly expect you to. So it's important to make a very complete record in your report. If you have any concerns about a person who is frustrating the process, or about whether or not you think that they're sitting there silently, go ahead and turn on your recorder. Record it. Let the judge, let the defense attorney, let the potential jury hear how frustrating they are, how aggravating they are, if they're being verbally aggressive or angry with you. Let them hear that. Let them know what you had to go through with this defendant. A lot of times, a recording of that nature helps prevent a DWI from going to either a contested hearing or to a jury trial. If you have any questions or concerns about this training video, feel free to contact either myself or Bill Lemons at the contact information provided.